the materia too, right?
Mr. Chair, it's really unfortunate that the Minister is prepared to deliberately misinterpret the issues, particularly on the question of equitable treatment under the law for what is private title and what is customary title. And the argument is, and it was the argument that was upheld by the UN Committee on the Elimination of Racial Discrimination and by the panel that looked at the issue, that there is to be equitable treatment of Māori forms of title and other forms of title. And it's not a question of whether there should be a confiscation of private title. The question is, if you're going to have a principle of public access, and I don't know how come David Parker managed to completely misunderstand this, if you're going to have a principle like public access, then there is no justification for saying that principle should only apply to some forms of title and not others. Well, what you do if you want to protect against things like public safety, for example, or you might want to protect environmental values of particularly sensitive areas, or there might be some reason why, rational, logical reason why public access shouldn't be provided for that particular land, then you can set out a set of criteria and ways of managing those decisions. But the title of the land should be irrelevant to whether or not the principle applies. The principle should apply in accordance with the needs of the public and the issues pertaining to that particular kind of land because of things like environmental sensibility, rahui, for example, particular kinds of use, public safety. The issue for the Greens and for Māori, because on this issue we have consistently spoken for Māori on this issue, is equitable treatment under the law and the rightful customary title and Māori forms of tikanga title to be treated equitably by the legislation. That was not the case in 2004. It is not the case here, because the principles, for example, of public access apply differently to different forms of title. So, just clearing that matter up, because it doesn't matter how much other people want to try to misinterpret that issue. That is the clear principled position on that issue around, for example, public access. So I have an amendment to Part 1 to delete Clause 9 of the bill, and it's related to Clause 8, but that's okay. What the issue is, I referred to it earlier in another call, is around accommodated activities, and this is where there are government agencies, Crown entities, public works, various kinds of things like this, that are activities that could occur or are occurring on what is customary marine title land. And the process in the bill says that there's all of these definitions for the people that can have these kinds of activities and the kinds of activities they could be, and that if they impact on customary marine title land, then the Minister effectively has the right to use that land, to take that land, to acquire it, to damage it if the Minister chooses to, and then enters into a negotiation with the holders of that customary marine title over what compensation might be available. I want to go through the legislation because it's a technical point, but it is important because, again, this is one of those discriminatory aspects of the bill that shows that Māori title is being treated differently from other kinds of title, and one of the reasons why this bill is considered to be discriminatory in terms of racial, in ethnic terms. Now, the legislation sets out in Clause 8 about what kind of things can be considered to be part of an accommodated activity, renewing an existing resource consent, an existing structure, upgrading existing structures, replacement or relocation of existing structures or infrastructure, dredging, which is a major issue for Māori in coastal areas. Dredging is one of those activities. And that could mean things like using this land, coastal marine area, as a dump. For discharge, for example, for the discharge of sewage, for example. And if a council wanted to use a area of land as a discharge point for sewage, for example, in emergency situations, then there's a capacity for them to make an argument and make an application under this legislation to use someone's customary marine area as a dump for sewage. Mr Chair.
Materia Ture.
Thank you, Mr Chair. The clause 8 also goes on to describe who might be able to make such an application for a deemed activity, emergency activity, accommodated activity, the Crown, any Crown entity, a network utility operator within the meaning of the Resource Management Act, electricity generator, a port company, Maritime New Zealand, the Auckland Regional Transport Authority. So the possibilities, the organisations that could seek to use iwi or hapu's marine land for this purpose is very broad, and the powers are very significant. In Clause 9, it talks about a deemed accommodated activity, which appears to be an extension. But one of the activities listed in Clause 9 is prospecting, exploration, mining operations, or other forms of mining under the Crown Minerals Act. And of course, marine mining is mining in general, but marine mining is a particularly sensitive issue for Māori at the moment. There have been numerous claims to the Waitangi Tribunal dealing with the right of Māori to have some say over what happens in their coastal areas, the erohe, around mining applications. They have been upheld by the Tribunal but denied consistently by the Crown. And this legislation again gives the right to others, Crown entities or their agents, to be able to make application to use Māori customary marine area for the purposes of mining and mineral mining. And the legislation goes on in the schedule to talk about what happens with an application to undertake that activity in a customary marine area. And what it says in Clause 8 of Schedule 1 is that the Minister has to consider the application and any information provided by the customary marine title holders. And one of those things is whether to waive the customary marine titles holders' permission, their permission rights, whether there are other rights that are affected, and whether or not to provide compensation. So the Minister makes the ultimate decision that if a company wants to go onto marine Māori held customary marine area land and undertake mining activities on that land, contrary to the wishes of the holder of the rights, the title to that area, then the Minister can provide and can then additionally decide whether or not to provide compensation of the use or damage to that land. Are completely beholden to the intentions and desires of the Minister as to whether or not their land is able to be used by them freely, and whether or not somebody else might want to use that land for something else that they consider to be more important than the iwi or hapu who hold that land, and whether or not the Minister thinks it's important enough for them to be given any kind of financial compensation for its loss. And we, the Green Party, again says if we're going to treat land equitably, regardless of the title of the land, then have the same laws apply. And for freehold land, that's the Public Works Act, which has a system for the provision of compensation. Compensation is not negotiable in the Public Works Act, but it is negotiable when it comes to Māori tikanga title. That is negotiable, because Māori, according to the government, the Māori Party and to National Party, if Māori are holding title in an area of land, that is just not as important as anybody else's title. And that can be taken off them for somebody else's economic use or somebody else's deliberate destruction for their own purposes, and the government can decide that actually it's not worth anything, so won't give them compensation. That is what these provisions in this bill do. That is how this bill is discriminatory against Māori and against Māori forms of title. It is grossly inappropriate to have such a different form of process for the use of what is in effect supposed to be being treated like private land from other kinds of land. It is not appropriate to have such a discriminatory, racist racist provisions in this legislation, and the Green Party is opposed to that, and we have our amendment to take it out. I understand that the Labour Party does the same and has a similar amendment to remove those clauses, and we will be supporting that if it comes up first, and certainly hope that the Labour will support ours if it comes up first, because there is no justification for treating these two different kinds of title differently. Thank you.
The Honourable